Hello. Today I'm going to discuss retaliation claims with you. Many different employment laws have retaliation provisions, and basically, a retaliation provision protects an employee for speaking up about some kind of illegal activity at their company. Retaliation claims are some of the best employment law claims because they are a little bit easier to prove much of the time. So we're going to talk about what it takes to prove a retaliation claim. As I mentioned, there are many different laws with the retaliation claims, so I'm just going to focus on one law as an example, Title VII of the Civil Rights Act of 1964, which is the main federal discrimination law in the U.S. There are 4 steps to proving a retaliation claim under Title VII. The first step is that an employee needs to have engaged in a protected activity to trigger legal protection. There are 2 types of protected activity. The first is opposition to acts that violate Title VII. Basically, this means an employee complained about some behavior that they believe is illegal under Title VII. Does the employee have to be sure the behavior is illegal? No. They just have to have a good faith belief that it's illegal. Does the employee need to be the person harmed by the behavior? No. They just need to know of the behavior. Does the employee have to complain to HR? No. As long as the employee complains to someone in management at the company, that's enough. And does the employee need to say the word illegal as part of their complaint? No. They just need to complain about the underlying acts. So for example, if someone complained that they saw their boss grope another employee in the hallway, they could just say that, and that would be protected activity. They wouldn't need to say that they believe that that's illegal. Does the complaint need to be in writing? No, it doesn't have to be in writing, although it is easier to prove the retaliation claim if the complaint was in writing and the employee retained a copy of it. Some jurisdictions think that even refusing a supervisor's sexual advances is enough to constitute protected activity. So besides opposition, the other type of protected activity is participation in an investigation or lawsuit that involves legal claims under Title VII. This could be something as simple as discussing what you know with an investigator hired by the company, and as elaborate as testifying in court in someone else's lawsuit. So the next step after the protected activity for proving a retaliation claim is that the employer must have knowledge of the protected activity. If you complain to a manager, then the company has knowledge. And it's also easier to prove that you made the complaint. But, say that an employee complained to their friend or their brother or to a coworker who's not a manager, then the company doesn't necessarily have knowledge of the protected activity. So after the employee complains and the employer is aware of the complaint, the next step for a retaliation claim is that the company took some kind of adverse action against the employee. Something like terminating the employee would obviously count as an adverse action, but the standard is just that the employer took an action that may well deter a reasonable employee from engaging in protected activity. So this could be demotion, a forced leave, an unfair negative performance review that affects the employee's compensation or standing within the company, exclusion from training, any number of things. And then the final step in proving a retaliation claim is that the protected activity must have caused the adverse action. Now, sometimes someone at the company will admit as much, but often they will not. So in those cases, the timing between the protected activity and the adverse action, or the company's reasoning for why they took the adverse action, could help to prove that retaliation happened and that the protected activity caused the action. Specifically, if the employer's reason doesn't make sense, then that would help to show that retaliation was the real reason. So Besides, if you have all these elements, then you likely have a retaliation claim. Title VII is one example of a law that, has retaliation provision. Most discrimination laws have a retaliation provision, whether it's the federal law or, a state or local law. Wage and hour laws protecting employees' right to earn a minimum wage or, earn overtime, those also have retaliation provisions. The OSHA, which basically protects workplace safety and health standards, has a retaliation provision. So does the National Labor Relations Act. So there are many different employment laws that have retaliation provisions. So you should feel free to speak up if you think that there's illegal activity happening in your workplace, and make sure that you have a record of your complaint in case something bad happens later. If you have any questions about whether to make a complaint or about whether you experience retaliation, reach out to an employment lawyer. Thanks for tuning in today.